Powell case, counsel, and your client may take your seat at the counsel table. Mr. Holmes, this is your motion, so I'm going to let you begin the argument.
Please, the panel, I'll go ahead and start my argument.
Yes, come to the podium, please.
I'm Bob Holmes, and I come to represent Ms. Powell in the cases that the bar filed against her, first in district court, and then we held the compulsory disciplinary hearings. And we believe that the compulsory disciplinary petition should be dismissed as a matter of statutory law. When you look at the definitions of, or start with, compulsory discipline only applies when a Texas lawyer has been convicted of an intentional crime or is on probation of an intentional crime. So you go second to what is the definition of an intentional crime. The first step is a serious crime. There are some additions to serious crime. It's got to be a serious crime of this and this. But first, it must be a serious crime. And so then you go down to Texas Rule of Disciplinary Procedure 106Z. The serious crime is barratry or any felony, and this is not a felony. These were all misdemeanors. And then it says a misdemeanor involving theft, embezzlement, fraudulent or reckless misappropriation of money, stealing some client's money, taking some money from a bank, not paying it back, any of those acts, or attempting or committing conspiracy to do any of those serious crime acts. And I've cited the court a case in my supplement to the supplement, in Ray Caballero, which was a 2008 case, which was brought about before the code was amended. So the statutes there are different. In Caballero, it was 106T and 106Z, and those are now 106B and 106GG. So you've got to go back to look at what did Mrs. Powell plead to, not what she was accused of. Our case law, Supreme Court has said that you look at the out of what was pled to, not what was behind, what Ms. Powell's previous history was, or whatever else has gone on. Well, Georgia Code, she pled to two misdemeanor statutes. The first, Georgia Code 14164-8, and that's a conspiracy claim. You can't plead to conspiracy unless there's a subcase. So, and what did Mrs. Powell actually plead to that set up the conspiracy issue was 21-2597. And that's a crime under Title 21 of the Election Code of Georgia, and quotes that case. That statute says any person who intentionally interferes with, hinders, or delays, or attempts to interfere with, hinder, or delay any other person in the performance of any act or duty authorized or imposed by this chapter, again, which is the Election Code chapter. And when you look at those specific things, what Mrs. Powell pled to, there were none of the issues of what a serious crime is in Texas. There's no fraud, there's no theft, no barratry, no embezzlement, no misappropriation of money, property, or otherwise. And so, when you look at that, and again, our Supreme Court has said that you look at what Mrs. Powell pled to, not the facts of the underlying case. One more thing that I might bring to the court's attention. The original indictment, which the bar now wants to argue, the accusation was dismissed. And I submitted an amendment yesterday, I believe, or the day before, adding as Exhibit 8 the order of the Georgia court dismissing the indictment against Ms. Powell. So basically what's before this court and what can be argued is what Mrs. Powell pled to. If this panel has any questions, I'll be glad to answer.
Any questions? All right, thank you. Save the time for a vote.
Your Honor, I did not offer any exhibits, and I didn't know whether you wanted me to offer those or not before that hearing on the motion to dismiss, but I will offer the exhibits that are in the second amended exhibit and list and the exhibits attached to that.
Is that been numbered?
Sir?
Is it numbered, or the exhibits numbered?
The exhibits are numbered 1 through 8.
All right. And do you have any objection in this case?
Yes, Your Honor. We object to Exhibit 4, which is a 1998-99 Georgia opinion of the Attorney General, as it's irrelevant because it's a Georgia, it's not binding, but also as are opinions by the Texas Attorney General, they're also not binding on the disciplinary proceedings. So we object to its relevance.
Any response to that?
Your Honor, it basically, that exhibit basically states that this is such an insignificant crime in Georgia that when you get accused or indicted,
Please don't tell what's in an unadmitted exhibit. Do you have any response to her objection?
Objections are, it stands on its face as an order of
Any other objections to 1 through 8 in the recently submitted exhibits?
Specifically that it's non-binding and irrelevant.
Sustain your objection to number 4, 1 through 3, and 5 through 8 are admitted.
I have a second objection.
I'm sorry?
I have a second objection. My second objection is to number 8, which is the nolle prosequi that was added to the second amended corrected list. For similar reasons, it's irrelevant in this case because we're talking about the plea and the judgment that Ms. Powell signed as guilty.
Well, Your Honor, that's an order of a Georgia court that the courts in Texas, and I've asked.
I'll overrule that objection. I'll amend 1 through 3 and 5 through 8.
And
Thank you.
may I ask for a clarification of Mr. Holmes? Mr. Holmes, you had also asked that judicial notice be taken of all 8 of these exhibits. Are you reissuing that now?
I am asking the panel to do that because under our Texas rules, you have the right to do that because they are Georgia laws and are orders of the court.
You admitted copies of the Georgia laws?
Yes, I did.
All right, well, we'll take judicial notice of the admitted statutes.
Thank you, Your Honor.
All right.
Thank you, Judge Kirkendall. May I proceed? Okay. Something that Mr. Holmes did not address, but I would like to address, is how we got here to this compulsory disciplinary proceeding today. Mr. Holmes has argued in his answers as well as in his motion to dismiss that we're here because of third parties who submitted information to the bar in an attempt to, I think he calls it lawfare, but what I am here to do today and for this motion, the statute 801 of the Compulsory Disciplinary Statute Part 8 states that when an attorney licensed to practice law in Texas has been convicted of an intentional crime or has been placed on probation for an intentional crime with or without an adjudication of guilt, the Chief Disciplinary Counsel shall initiate a disciplinary action seeking compulsory discipline pursuant to this part. So I want to make it abundantly clear for the record, we are here because it is the position of the commission, the petitioner in this matter, that the crimes pled guilty to by Ms. Powell are intentional and serious crimes and therefore require us by statute to come and make this argument. Now, it's in the board's discretion to decide whether or not they believe that the crimes are in fact intentional and serious. But we are here because the statute requires our office to do so. And that is why we are here, not because of any other reason.
We'd like to know why you think they're serious crime.
Yes, sir. And that is I'll come back to that as my second argument.
But counsel, if you all did not think that that was the case, you'd not bring the case, right?
We wouldn't have the requirement by the statute to do so. And we do believe that they are, and therefore we must be here.
How does the crime pled to meet the definition of serious crime?
Yes, sir.
Barratry, etc.
Rule 1.06 GG of the rules defines a serious crime as barratry, semicolon. And the punctuation here to me is very important. Barratry, so as its own thing, any type of barratry, felony barratry, misdemeanor barratry, all barratry qualifies. Any felony involving moral turpitude. We've recently been here in the last several POTA sessions talking exactly about that, whether something falls under a crime of moral turpitude or not. That's not what I'm here to argue today, whether or not the crimes are moral turpitude. Ms. Powell, in her judgment, specifically says these crimes are not crimes of moral turpitude. But then we get to the next, again, there's a semicolon, so next clause, any misdemeanor involving theft, embezzlement, or fraudulent or reckless misappropriation of money or other property. Involving theft, embezzlement, or fraudulent or reckless misappropriation. Those words are not defined any further than the plain meaning of those words. Theft has many different meanings in the legal field, in the civil field, the criminal field, and in the plain parlance. Right? Somebody takes your pencil and never gives it back. That is theft. That is the broad meaning of the word theft. The statutory language here did not give us further parameters, presumably because any theft by a lawyer, a person with power, a person with authority, a person whose mere words hold more weight than your average person.
What's alleged to be stolen here?
Voter data. So this is when we're going to get into talking about, if you will permit me to do so, the accusations. Now, I understand that Mr. Holmes is arguing that the accusations should not be considered here. And I want to make two different distinctions. One, I will offer in a moment the accusations and all of my exhibits on my list. I think it is very important to note that the final judgment references the accusations. It specifically says, as indicted or accused. It's incorporated by reference because it's a lot of words. There are 6 counts. And each of those 6 counts lays out how Ms. Powell, I'm sorry, I'm speaking very fast, how Ms. Powell hired Strickler PLLC, paid them to go to Georgia, somehow gain entrance to the voter... Yes, sir.
Is in the Georgia statute, is the taking of data or theft or taking of any property, is that an element of the election fraud offense?
I'm sorry, will you ask your question again?
Sure. In the Georgia statute that Ms. Powell pled to,
The 16.48, is that what you're specifically referencing?
the 21...
Yes, sir.
Is it 21.5, whatever, is taking of property or theft, is that an element that is required to prove election fraud under the Georgia statute?
There is no, the statute itself, 21, the statute you are referencing, is particularly vague. What it specifically references is an intentional interference with voter duties. And so while the statute itself doesn't have the language of theft or a taking, that's exactly why we're arguing they chose to incorporate the accusation, because many different things could be held to be voter interference. As Mr. Holmes has stated, simply, which I disagree with, but simply having a polite chat with someone outside their office door that keeps them from attending to their voter duties could be brought under the statute. I argue with that a little bit because, again, there is an intentionality requirement. So if you're saying hi to Linda, the voter registrator, or whoever she may be, unless you are intending to keep her from doing her job with election duties, that doesn't count. So I argue that the way the statute for that is written, and it's what she pled to, could have many different implications, which is why they specify that you have to look to the accusation or the indictment for the exact specifications of why that was pled to.
Do you have an opinion from the Georgia Supreme Court backing up that argument?
I don't think it's ever come to them, that specificity of argument. And I know that Mr. Holmes has also argued that she could have pled to taking of voter data, or she could have pled to theft, or she could have, but she couldn't because she wouldn't have. She tells you that. She says she specifically pled to these charges because they agreed that they weren't going to be crimes of moral turpitude, and she wouldn't have agreed otherwise. So we could be here 3 years down the road if there had been a trial, and maybe they had brought charges or convicted her of something different.
But counsel, they didn't do that. Explain to me in 21-2597 where the text of that statute supports the argument you're making.
The statute itself?
Yes.
The statute is very vague and plain. It specifically only references the intentional interference of voter duties.
So the text of 21-2597 does not contain the requirements that are in TRDP 106 GG. Yeah, we're just agreement on that?
Yes, but I have to say yes to your question. But I also, if you may, to go off of, because all of these questions that have been asked to me, I want to make it also clear that whether or not it is an intentional crime or a serious crime is a compulsory disciplinary matter for the board to decide. It's not for a motion to dismiss.
Did I just understand you to say it can be intentional or serious?
No, well, it has to be intentional, and by intentional has to be a serious crime, or that is what we are here talking about, correct?
You need both.
In this particular instance, we're arguing that there are both, yes.
Okay.
And that you need both.
Correct.
But if 21-2597 is not a serious crime, then this is not a compulsory matter. Is that right?
That is not, it doesn't work that way. So it's kind of a rectangle is not a square, but a square is a rectangle. So that is the legal argument to be made for a compulsory matter. It's basically, there is a legal question to be answered by the board in a compulsory matter. So to say that we're here on it's more appropriate that he's filing a summary judgment motion than saying that there is not a legal argument to be made. And there is a distinction there. There is a direct legal distinction there.
So I think, let me see if I can procedurally parse out your argument. Do I understand you to be arguing that the question on the 91A involves only the intentionality, and then the merits, if you might, are intentionality and serious?
Not exactly. I'm arguing that the 91A is saying that we as the petitioner don't have a legal reason to be here. And the legal reason is for the panel to decide whether or not there is whether the crimes Ms. Powell pled to are serious and thereby and also intentional, and that is subject to compulsory discipline.
And it is your position that that is the case?
Correct.
And how is that position based on the text of 21-2597?
Again, because what is encompassed in what she pled to, again, as incorporated by the judgment, you have to understand, the record of conviction is what the Texas courts say we can look at. That's what the language in the rule specifically says. It says for a compulsory discipline, we look to the record of conviction. And there is Texas law, settled law, that says the record of conviction includes the indictment as well as the judgment. And presumably that is because, and especially you can see in these cases, in Georgia they call it an accusation, here we would call it an indictment. So you have to say, you have to get all the encompassing documentation, which is not always going to be held solely in the judgment. It's very similar to how this court does its orders. Sometimes we get an order that just says the petitioner's motions are granted and we don't need any further information. Sometimes you need that further information to be able to glean what the purposes of the arbiter means. And in this particular case, because the judgment specifically references the accusations, and the case law in Texas says the record of conviction is what to be considered, that also includes the accusation here. That's how we meet our burden.
This case, let's talk about the case law for just a second. How do you get to the indictment in light of Locke, Duncan, and Humphreys, which seem to strongly suggest that compulsory discipline is supposed to be a summary proceeding, that it's immediate, and that it turns on the elements of the crime per se? How do you, I assume you overcome that case law by saying that the record of conviction is an expansive term that embraces everything. Do you overcome Locke, Duncan, and Humphreys based on your conception of the breadth of the record of conviction? Is that right?
You have phrased that perfectly. I could not have argued it better myself. I do. And to give you some further information on that,
how is that possible under Locke,
that's exactly
Duncan, and Humphreys?
Yes, sir. In Locke and Duncan and Humphreys, if you look closer at what they are actually arguing, all of those involve crimes of moral turpitude, and they specifically talk about using the judgment only in so much as you are attempting to confirm that a crime of moral turpitude that is not per se, so has already been determined to be one, that is what you can look to determine whether a crime is a crime of moral turpitude. It does not, none of them stand for the premise that you cannot use extenuating other documents when you are looking to intentionality, which is what I argued in Mr. Herring's case, this last VOTA, as well as, in this particular case, including theft. And again, theft is so, when you say theft, the average person has a feeling about it. And if you said, your attorney...
Well, we're not going to decide this based on people's feelings.
I'm not, but I do think that the public policy argument is important in terms of why these three misdemeanors are carved out individually and not given a Texas Penal Code reference, not given a further legal definition, no footnote, no comment. They are meant to be taken as plain language of the statute.
Right, and the plain language of the statute doesn't have anything...
Of the statute that controls the compulsory disciplinary matter.
You refer to it as a rule. Sorry, I was confused. It's a
I
rule, not a
apologize.
statute. Right, so the record of conviction includes everything, and Justice Owen's concurrence, and I guess she said, "Hey, let's look at the indictment and let's get to the bottom of this." And the majority conspicuously didn't do that, and then the other concurrence, I believe. Or no, they were both dissents, right? The other separate writing, former Chief Justice Heck's opinion, also didn't use the indictment. How do you square those opinions with the idea that we can look at the accusation or the indictment? Just that specific case.
So I will, which specific case would you like?
The one where you got three separate writings, and the dissent says, hey, well, you can use the indictment. The majority doesn't use the indictment, and then the other separate writing doesn't use the indictment either.
Well, a review of this board's history will show you that the indictment has frequently been considered.
So a decision of this board can trump a decision of the Texas Supreme Court.
I think this board has broad discretion, and I think...
Can we have discretion to undo a Supreme Court precedent?
I'd love to give you a full answer, which is the Supreme Court has made their decision. And it is for this board to determine whether they choose to agree with that or disagree with that. I've already explained to you how the position of the commission says that Locke does not stand for the premise that you can only look to that specific document. That it gives levity, it gives leeway for you to look at the record of conviction, which is more expansive, In the question of intentionality, and as I argued in Mr. Herring, because with intentionality, you need to know the facts to know whether this person did it intentionally or not. Sometimes the order and the judgment are not enough. And also, in cases of trying to determine whether or not something is theft. This, I believe, based on my research, is a novel argument being made by the commission. I don't have any other case law that would tell us how this is supposed to go. What I can tell you is I've read Locke and Humphrey and all of the cases surrounding this, and I stand for the premise I've just given you. And additionally, can I make just one small point about the conspiracy, specifically about conspiracy. Conspiracy for many different things has been brought in front of this board on many occasions. And in many of them, and I'm happy to provide supplemental briefing if you want, the indictment was in fact looked at to determine whether or not the case qualified for compulsory discipline. I apologize, Mr.
That's
President.
okay. My question is when, assuming that the broader reading of record of conviction includes the indictment or accusation, when the charging instrument includes non-statutory information, so specifically facts surrounding the underlying offense, are you saying we get to consider those underlying facts?
I think based on the reading of Locke and Duncan and Humphreys, to determine whether or not this case falls under a case of involving a misdemeanor involving theft, I do believe you can.
I'm sure I understand your argument. So you're saying the Locke line of cases and its command to only look at the elements of the case only applies when you have a moral turpitude definition question?
I am telling you that that's what those cases say in all of their dicta. They are all specifically deciding whether or not the crimes pled were crimes of moral turpitude. They don't even get into the other issues surrounding the language of the requirements in Section 8.
But you can see that's just dicta, right? You just said it, right?
I said dicta, and it was the wrong choice of word, because the case matters. The case, obviously, we've talked about these three cases in the last 5 times I've been here. They are obviously very, very important, and that's why the whole case matters. They are specifically determining cases about moral turpitude, and we've already conceded, and the judgment states they are not crimes of moral turpitude. That's why those cases are only so helpful to us in this particular case.
Well, in this case, you mentioned the previous cases that the board considered in the last en banc session. My recollection is when we were looking at the charging instruments in those, we were looking at them for the statutory language of the offense. Is that correct?
That would be information I wasn't privileged to, nor is it, I don't know. I can't answer your question because I'm not sure if that's what you ultimately
Well,
determine.
as far as the exhibits that CDC submitted.
In this case or the last
In
case?
the previous case, you submitted the judgment, you submitted the indictment, correct?
Yes, sir.
And you urged us to look at that as the total record of conviction, correct?
Yes, sir.
And in those cases, we were looking at the charging instrument for the statutory elements of the offense to determine whether or not it warranted compulsory discipline, correct?
So my recollection, specifically about Mr. Herring's case, was that the intentionality requirement was what we were looking at in regards to the accusation. And so that is exactly what I'm arguing here, essentially. In that case, we were able to use the accusation because we're not talking about moral turpitude. We're trying to get it facts to determine whether or not there's an intentionality. Here, as I've argued numerous times, the statute, we don't seem to be asking much about intentionality, and that's because the statute itself is the intentional interference. It's in the words of the statute itself, it's in the words of the name of the statute, so then we're not talking about that, right? It's not the same necessarily as Mr. Herring, but as in Mr. Herring, the record of conviction, which would include the indictment and the accusation, here are going to help us expand the statute, which only tells us about interference of election duties, which gets us nowhere to how it occurred, which in this particular case, and in many other particular cases, would significantly matter if, as Mr. Holmes argues is the same, Ms. Powell just stopped Linda outside her office. I don't think we'd be here. Because it would then be very difficult to determine intentionality, again, without the accusation, which is why you need the accusation here to get to the rest of the words of the statute. Our rules, which I do believe are codified, the statute in the government code, but our rules.
All right, Ms. Gates, you've used your 15 minutes, most of it answering questions, so I'll give you some more time if you need it. Do you have any conclusory remarks?
I think I have made, with your wonderful questions, the argument the best I can, because I think your questions have allowed me to give my argument. I would like to ask that my exhibits be entered at this time. I can read them for you, or they are on our list. I also have a question. My exhibits for the response I filed, do I need to offer those into the record, or are they in the record as part of my brief?
You can have your case however you choose to handle it.
Okay, well then, for the sake of clarity, I will offer them as well.
But what are the numbers of the exhibits?
Yes, sir.
you offer?
Exhibit 1 is the accusation in Ms. Powell's criminal case. It is unsigned. There are two versions. So there is an unsigned version, which is Exhibit 1, and a signed version, which is Exhibit 2. I move to offer those at this time.
Your Honor, I object to both of those because they have been expunged from the record, so to speak.
Were
They're
those the
gone.
ones that
They've
were
been-
dismissed, or were those the
No,
ones
sir.
that filed for the plea bargain?
They're as incorporated by the final judgment.
Those are not as incorporated by the final judgment. They're standalone accusations, Exhibit 1 and 2, and I have not objected to the non-pro-tunc order, which is the live order in that case, not the previous order. And I believe that those should not be part of the record and should be struck from the record because those have been removed from the record as per the Georgia order under my Exhibit A.
I think you misunderstand what she's introducing.
No, those are the exact, that's the indictment against Ms. Powell.
No, this is not the indictment. This is the accusation that was filed as part of the plea agreement, is what I understand she's offering. Is that correct, Ms. Gates?
It is, but I think in this particular case, we're quibbling about a word that has a difference without a distinction without a difference. Because in this case, they don't have an indictment. I believe that their version of the indictment is in fact called the accusation. And if I may respond to his objection, or not.
You may quickly.
Yes, sir. I will argue that the accusations, despite what the board's ultimate determination is and whether they choose to look at them to prove the language of the statute, are still certified copies of what occurred and what Ms. Powell ultimately pled to in this case.
I'm going to sustain this objection to the unsigned one. I'm going to admit the signed one if it's a certified copy.
Yes, sir. I'd like to enter Exhibit 3, which is the guilty plea signed by Ms. Powell.
No objection, Your Honor.
It's admitted.
Exhibit 4, and I will say this is slightly duplicative because it is already, the final judgment has been entered by Mr. Holmes. However, there is a final judgment, and then there is an amended final judgment, and so my Exhibit 4 would include both the original and the amended.
If Exhibit 4 is just the original, then I have an objection because, again, that is not the live order in this case. In that case, the live order is the non-pro-tunc order, which I have entered, and that is not the non-pro-tunc order. Did I hear you correct?
I am offering the final judgment as signed on...
Please don't have any conversations between the lawyers. Direct your conversations to
I apologize, Judge. Do you have a question?
certified copy?
Yes, sir.
All right, it's admitted. Yeah.
I'd also move to enter Exhibit 5, which is my signed affidavit stating that Ms. Powell is the individual referenced in our petition and is licensed in Texas.
Any objection?
Your Honor, we will stipulate that Mrs. Powell is the person that
All
was...
right, I'll admit it. Go ahead.
Yes.
Exhibit 6 is the Blake Hawthorne letter from the clerk of the Supreme Court stating that Ms. Powell is licensed in Texas.
Any
No
objection?
objection.
It's admitted.
And for the sake of this, I think I'm missing 2. I have petitioner's response, Exhibit 1, which is the service packet attempts for the original petition.
What is it?
It is my response exhibit 1, so the response memo brief I filed.
This is brief.
This is the exhibit attached to my brief. One of the exhibits, exhibit 1.
We object to that, Your Honor. Again, that's not the live pleading in the case. It was.
Sustain the objection. Next.
Similarly, so the brief, my exhibit to my brief is struck from the record.
I've sustained the objection. Move on, please.
Exhibit 2 is service attempts of the first amended petition.
What's the point of that?
Objection order of those two, Your Honor, same thing. I mean,
I asked her, what's the point of that?
I asked you for clarity in the beginning whether or not the exhibits attached to the brief I filed would be part of the record without me entering them, and you said I should run my case, so I'm just trying to offer for completeness of the record.
Sustain the objection.
Then I have no further records at this time. Thank you.
Thank you. Counsel, you have 8 minutes to respond if you choose.
I hope I don't take that long. The bar continues, in my opinion, to find the crime serious, intentional, as a crime of intentional and serious. And that's not what disciplinary rules say. Disciplinary rules clearly say that before there can be a compulsory eviction, disciplinary case filed in this state, that it must be an intentional crime, and then intentional crime is defined by a serious crime. It's not a serious and intentional crime. And I think it gets clear whether or not they're, how does the crime get, not a question, I'm asking myself a question and anybody else in the room. How does a crime get committed that's not intentionally committed? Whether you walk up somebody on the street and steal their pen or walk in and steal their money. So the intentional is a broad definition that includes the items in what is defined as a serious crime. And I think the bar continues to confuse that, and I just want to point that out. I think the other issue that I think is very important, and I did not cite the statute, but in Georgia there is a similar statute under the election code, Georgia Code annotated 21-2-603, which I will ask the court to take judicial notice of it too, since it's a statute of another state.
Counsel, we're not able to take judicial notice of a foreign statute that hasn't been admitted before us.
Sir?
We can't take judicial notice of a foreign statute we haven't seen that hasn't been admitted.
I understand, but that statute...
It's a legal authority. It's okay. We can go on Westlaw and see that legal authority. Don't worry about it.
Well, that statute clearly states that threatening violence, that would be a serious crime, willfully blocks or attempts to block avenue to the court, threatens violence, willfully prepares or presents any poll, officer, or fraudulent voter certificate, knowingly deposits fraudulent ballots, knowingly registers fraudulent ballots. And my point is, if Georgia and Ms. Powell had intended for her to plead to a crime defined as a serious crime in the state of Texas, don't you think they might have included that statute as opposed to the statute they included? Because the Georgia statute that Mrs. Powell pled to, and again, conspiracy is not a crime unless there's an underlying crime. We can all conspire sitting right here. We're going to have lunch over here at Elaine's tonight. That's a conspiracy, but it's not a crime. So my point is, the specific statute that Mrs. Powell pled to has absolutely no definition of a moral turpitude crime or any crime that is a serious crime as defined in statute of the state of Texas. And again, I disagree completely with the bar's statement of the cases that the Supreme Court has said, you look at what the person pled to, not what he was accused of. There is not dicta in those cases. Caballero is an old case, but it is still valid. It is still the law. And that court, that Supreme Court in that state case said specifically, it is not an intentional crime, which is a serious crime, there should not be a case filed in Texas.
How do you respond to her argument, though, that those were all moral turpitude cases? And the court said we're just going to confine ourselves to a review of the elements of the offense because moral turpitude is less finite than the definition for theft, for example. What do you say to that argument?
Aren't we here today arguing over whether or not what Mrs. Powell pled to is a moral turpitude crime or not, Mr. Pistos? No. Isn't that the sole question before the court?
My question to you is, how do you respond to opposing counsel's arguments that the command under Locke and that line of cases, that we should only look to the elements of the offense, is combined only because those cases were moral turpitude cases? And the CEC and this board is free to use a different interpretation because this is not a moral turpitude case.
The issue there is you go back and look at the Caballero case.
Was Caballero a moral turpitude case?
Sir?
Was the Caballero case a moral turpitude case?
No, it was a lawsuit filed on the same similar circumstances to Ms. Powell. And the Supreme Court said in that case, this case should not have been filed because it is not an intentional crime because it is not a defined serious crime. Nothing more, nothing less. It's a very short case.
What was the crime in that case?
Sir?
What was the crime in that case?
I'd have to look it up right quick. I can't recall.
If you give us some supplemental briefing on that, that would be helpful.
Okay, I will. Thank you. Nothing further, John.
All right, thank you. All right, the board's going to take a recess now. We'll step out and we'll be back to decide this motion. We'll be back in approximately. We'll take at least a 10-minute recess, so if you need to step outside the courtroom, feel free. When we come back, we'll take up the Cornejo case. Mr. Ferris, you and your client.
Yes, Your Honor.
Get ready at the council table. And we'll be back. Board's in recess. This is on the merits. We have determined that it was the decrease serious